Hello students, I'm Dr. Akanksha Srivastav and I'm Associate Professor in the Department of Business Administration at Lal Bahadur Shastri Group of Institutions, Lucknow. And in today's class, I will continue the remaining provisions of Employee Provident Fund and Miscellaneous Provision Act 1952, that is a part of Unit 5 of the subject Employee Relations and Labor Laws, which is there in MBA third semester as HR specialization, right. So, we will continue the Employee Provident Fund and Miscellaneous Provision Act 1952 in today's class. So, let us start. What I will discuss today under this act, the third scheme which I have already told you in the last class, this is the Employees Pension Scheme 1995, which is in operation under this act, and it was left in the last class, so we will cover it in today's class. The administration of the scheme, right, how this scheme has been administered, who's looking after of this scheme, who's taking decision for the scheme, how we will do that we'll see. Contribution to pension fund, how the fund is contributed for this particular scheme, that we will discuss today. And benefits for member under the scheme, what are the different kind of benefits there under this scheme for the employees who are covered by this scheme, that I will discuss. Then there are certain key amendments which are there in 2014, that is 1st September 2014. What are these amendments under this scheme, the employee pension scheme, that I will discuss. And then administration of the fund, the total fund which is contributed under all the three schemes, that is Employee Provident Fund scheme, Employee Deposit Linked Insurance scheme and this Employees Pension scheme, the total fund which is contributed, how that fund has been administered, that I will discuss. And determination of money due from employer, if there is any money which is due from the employer's side, then how that money can be determined, what is the procedure for that I will discuss. And in the last, the appeal to tribunal, if there is any grievance in the members of the act, then why that grievance is there and how that grievance will be settled. For that there is a body, and how an aggrieved person can appeal for his grievance, that we will discuss. And with this Employee Provident Fund and Miscellaneous Act 1950 will be over in today's class. So, let us start with the class. Okay. The Employee Pension Scheme, this is the third scheme under this Employee Provident Fund and Miscellaneous Provision Act 1952. So, according to this scheme, under section 6 subsection A, the purpose of the Employees Pension Scheme, there are certain objectives, certain aims of this scheme. And what are these aims? The first one is superannuation annuity. If any member or any employee who is eligible for the scheme reaches the age of 58, that is called a superannuation age, at that period of time he will receive, or he is entitled for superannuation annuity, right. As in the starting I have told you, it is a retirement benefit. Okay. Then second is retirement annuity. Retirement annuity is if any member takes any voluntary retirement before the age of superannuation, at that time also, because at that time again he separates from his employment, there is a termination of services, at that time also he is eligible for retirement annuity. Then there is a permanent total disablement annuity. There are many kinds of disablement. I am not getting into the detail of the disablement, but yes, to explain this, let's have an example. Like any employee is there in any establishment and who's operating one machine where his both the hands are required, right? And in any accident or in any mishappening, he lost his one hand. Now he is not capable enough to operate that machine. That is known as permanent total disablement. If he lost his one or two fingers, that is a permanent disablement again, but that is a permanent partial disablement, because in that case there is a possibility that he can operate that machine. But I am not talking about the permanent partial disablement. Here the term is in case of permanent total disablement, in which the employee become incapable of the job responsibility for that he is accountable, he will receive a permanent total disablement annuity, right? Then there is widow or widower's annuity, right? In case employee is a male and if he dies, then his wife will receive a widow annuity. In case an employee is a female and she dies, in that case her husband will receive a widower annuity, right? In place of this, the word spouse can be utilized, right? Spouse annuity, but it is in this way only according to the act: widow annuity and widower annuity. And then there is children and orphan annuity also. So these are certain objectives, certain aims of Employees Pension Scheme 1995. Now, the administration of a scheme. According to the specification given in the pension scheme, the Provident Fund shall vest and administered by the central board. Okay, there is a body, the name is central board, who is which is administer this scheme actually, and the name of the body is central board. The central government may add, amend or vary either prospectively or retrospectively all the three schemes under this act by giving notification in the official gazette, right? So who will administer the scheme? This center board, right? And central government has the power to add something in the provisions or to amend something in the provisions or vary something prospectively, that is on the basis of future, right? If we see yes, there may be certain changes in coming future, we need to add, amend or vary certain provisions in the scheme. So central government may do that. Or retrospectively, that means on the basis of past, experiences, if there are certain things which central government may feel yes, they should change or we should add something, so central government may add in all the three schemes, right? But yes, it has to provide a notification in the official gazette. So this was the administration of the scheme, of this employee pension scheme. So with this, all the schemes, all the three schemes which are in operation under this act is over, and these schemes were Employees Provident Fund Scheme, Employee Deposit Linked Insurance Scheme and Employees Pension Scheme. Now, okay, one thing is also there, that is contribution to pension fund. How the contribution has been done under this pension scheme. The scheme is financed by diverting 8.33% of the Provident Fund contribution from employer's share and by contribution of 1.6% of basic wages of employees by the central government. If you remember, when I was discussing about the contribution of employee provident fund scheme, where I have told you already, there is a employees contribution, right, and employers contribution. And they both need to contribute 10% of wages, and that wages is the wages of employee, the employee who's receiving the wages, 10% of that wages, right. It was there in EPF scheme, that was employee provident fund scheme. Employee needs to contribute 10% of his wages, and employer has to contribute 10% of wages of employees, right, on behalf of employee who is entitled for the scheme. So, what is written here? This scheme is financed by diverting 8.33% of provident fund contribution, right. This 10% contribution which was from the employer's side, from this 10%, the 8.33% will be diverted to this pension scheme. Okay, employee need not to contribute in this scheme. Only employer's share, which is 10% in provident fund contribution, from that 8.33% is diverted to this pension scheme. Other than this, 1.6% of basic wage, right, this is important, of basic wage of employees, it is contributed by the central government. What are the benefits for member under this scheme? First, there are many benefits. The first one is member pension. The employee who is member, that person will receive the benefit, who is entitled for the scheme or who is covered under the scheme. Then the disablement pension, due to any disability, because of that, if employee has become incapable of doing his job responsibility, in that case he will receive a pension. Widow or widower pension, in case of a male employee, if he dies, then his wife will receive the pension. In case of a female employee dies, then her husband will receive a widower pension. Then there is children pension. In case one parent dies, the children will receive the pension, and if the children is disabled, then again he will receive the pension. Pension for orphans also, if both the parents dies, then the kid or the children who become an orphan, he will receive a pension. Then the nominee pension, if the entitled or eligible employee nominated someone, case if something mishappened to me, then this particular person will receive the benefit of this scheme, then he can nominate someone, then there is a provision of nominee pension also. Then pension to dependent parents. It is not like that only employee who is entitled will receive the pension, or in case if he dies, his wife or husband will, or maybe receive, spouse may receive the pension, or kids or children receive the pension. If that eligible employee have dependent parents, if a member under this scheme has dependent parents, then these dependent parents are also eligible for the pension. Then there in last there is a withdrawal benefit. If any member want to withdraw some amount, he may withdraw that amount with certain conditions. These are certain benefits under this pension scheme. Okay, now the key amendments in 2014. What are the key amendments under this scheme? And it is effective from 1st September 2014. I have already told you the first amendment, that is wage ceiling was increased from rupees 6,500 to rupees 15,000. Before 1st September 2014, the wage ceiling was 6,500. After this amendment, the ceiling has been raised up to rupees 15,000. Pensionable salary shall be calculated on the average of monthly pay for the contribution period of last 60 months. Earlier it was 12 months and it is preceding the date of exit. As we have seen in previous classes also, that any benefit, it is calculated on the basis of salary, the average salary, right? Average monthly pay. Okay. So before the amendment, it was the 12-month contribution period, which has been increased up to last 60 months contribution period preceding the date of exit. This is an important amendment under this act. The monthly pension for any existing or future member shall not be less than rupees 1,000. It shall not be less than rupees 1,000 from the financial year 2014 and 15. The monthly pension of any existing member or future member, right? From the financial year 2014 and 15, the monthly pension, it should not be less than rupees 1,000 for any existing member or as well as any future member from the financial year 2014 and 15. These are certain amendments under this scheme in 2014 and which is effective from 1st September 2014. Okay. Now, the schemes are over here, all the three schemes are over here. Now we will talk about the total fund which is contributed under all the schemes, how it will be administered and who will administer this fund, which is the body which administer this fund, right? Because we are taking contribution from the employee for a long period, and we need to invest that amount somewhere for the revenue purpose, and at the time of termination of the employee services, we have to return it back with some interest. So the fund must be administered. So how and who will administer the fund, that we will see. According to section 5 subsection A, central government is empowered to constitute the centre board. This I have told you before also. The centre board is a body which administer the fund, and this body is consisting few persons as member, and these persons are one chairman, okay, one vice chairman, one central provident fund commissioner, 5 persons representing central government, 15 persons representing state government, 10 persons representing employers, 10 persons representing employees, right? So in total, central board constituting of 43 members. Just add 1 plus 1 2, 2 plus 1 3, 3 plus 5 8, 8 plus 15 23, 23 plus 10 33, 33 plus 10 43. Yes, there are 43 members in central board, and these 43 members administer the fund. The central board is basically the decision making body who takes the decision or who makes the decision regarding how the fund should be administered, right? It is a decision making or rule making body. There is one more body to assist this body, that is central board. What is this body? So in continuation of administration of fund, the another body is executive committee. Okay, and this executive committee provide assistance to central board. Whatever central board decide, this executive committee makes sure the applicability part of the administration of the fund. Whatever decision which has been taken by the central board, executive committee makes sure ki yes, that decision is implemented or not, and if there are certain deviations, then how we will take corrective actions for those deviations. Again, this executive committee has few persons as member, and who are these member? One chairman, one central provident fund commissioner, two representative of central government, three representative of state government, three representative of employers, and three representative of employees, right? So in total, EC constituting of 13 members. Just add 1 plus 1 2, 2 plus 2 4, 4 plus 3 7, 7 plus 3 10, and 10 plus 3 13. So there are 13 members in executive committee. Few members are common in center board and executive committee, but yes, in center board there are 43 members which are working, and in executive committee there are 13 members who are responsible for the administration of the fund, basically the application part, because this body assists the center board. Okay. So this was the administration of the fund. Now a very important clause, that is determination of money due from employer. If any money is due from the employer's part, then how this money can be determined. Okay. For dispute settlement, section 7 subsection A empowers the central provident fund commissioner. He can resolve this dispute. Dispute is basically what? Dispute is difference in opinion. If employer and employee is having any kind of dispute regarding the fund, then who will resolve that dispute? Who will settle down that dispute? The central provident fund commissioner. According to section 7A under this act, the central provident fund commissioner has power to resolve these kind of disputes. If central provident fund commissioner is not there, then in that case additional provident fund commissioner will resolve the dispute. If additional provident fund commissioner is not available, then deputy provident fund commissioner will resolve the dispute. And in the case when deputy provident fund commissioner is not available, in that case regional provident fund commissioner will resolve the dispute. And in case if regional provident fund commissioner is not available, then assistant provident fund commissioner will resolve the dispute. So these are basically those positions which assist this Central Provident Fund Commissioner. Basically, this Central Provident Fund Commissioner is responsible to resolving any dispute or settling any dispute. But in absence of Central Provident Fund Commissioner, these are the persons who can resolve the dispute. And dispute regarding what? Dispute regarding applicability. Right. If employee is saying no, I am eligible for more fund, and employer having different opinion over that, then this kind of dispute may be resolved by these commissioners. And determine the amount due from the employer. If any amount is due on the employer's part, then it will be determined by these commissioners. If any dispute is regarding the amount which is due on the employer's part, then this dispute is again resolved by Central Provident Fund Commissioner. Okay. Now, the appeal to tribunal. If there is any grievance is any kind of dissatisfaction, right? Real or imaginary or whatever. I am not going into the detail of the grievance, what is grievance. But if any grievance is there, then the member who is having the grievance, he need to appeal to the tribunal, and tribunal will resolve that grievance and try to sort out that grievance. So, any aggrieved person shall appeal to tribunal in following cases. Any notification issued or passed by central government. If central government has passed any notification to the act, then an aggrieved person may appeal except an order rejecting an application for review. If central government has already rejected the application for review, then for that notification person cannot appeal it to the tribunal, otherwise he may appeal to the tribunal. According to section 7A, no appeal by the employer shall be entertained by an tribunal unless he has deposited 75% of the amount due from him as determined by an officer. According to section 7A, if any employer has any kind of grievance, tribunal will not entertain that grievance until that employer has deposited 75% of the amount which is due from him, and it is determined by an officer. First he has to deposit that 75% of amount, and if he found correct, then that 75% of amount which has been deposited by him will be given him back. But if he may not found correct, in that case he need to pay the remaining 25% also. According to section 7Q, an employer is liable to pay simple interest of 12% per annum on amount due. An employer is liable to pay 12% per annum on the amount due. For what duration? From the date on which amount has become due till the date of its actual payment. Right. So, employer is liable to pay the interest of 12% per annum on any amount which is due on his part. So, these are the main important provisions under the Employee Provident Fund and Miscellaneous Provision Act 1952, and this act is over here. Thank you.